My name is Vincent Davis, and I'm an attorney here in California. This is my 31st year of practice, and I'm an expert at CPS cases, defending you in the CPS court, and also suing social workers for civil rights violations. Today we're going to talk about something very interesting, and it rarely comes up because I don't think a lot of people know the law in this particular area. You're at your first hearing, a detention hearing in CPS court, and the judge orders you to do drug testing. Well, this happened in a case with me here in Los Angeles County probably about 3 or 4 months ago. Now, what people don't realize is theoretically the judge doesn't have the power to order you to drug test at the detention hearing. Now, the judge may be able to order that drug testing later on in the case, but at that first hearing, the judge does not have jurisdiction to order drug testing. The problem is that most attorneys don't object to this, probably because they don't know they can object to it, or they feel that it might be beneficial for their clients. I have let judges order drug testing at the beginning of the case because I thought it would be beneficial for my client who I knew would test clean. But here's what the law actually is in California. And I'll tell you what happened at a court hearing 3 or 4 months ago in a case that I was handling. We made arguments regarding detention of the children away from my client, and the judge was going to temporarily detain the children away from my client. But in making those orders, the judge went on to say that she was ordering my client to drug test and to hair follicle test. And I objected. And I got a surprised look from the judge. First I told her, Your Honor, hair follicle tests in California are unconstitutional. So no matter what, my client doesn't ever have to hair follicle test in this case. Now, is hair follicle testing ever ordered and the parent has to hair follicle test? The answer is yes, only because the parent and or the attorney for the parent didn't object. So if a judge orders you to hair follicle test and you don't object and your attorney doesn't object, you got a hair follicle test. Now, the other argument in this case is, at the detention hearing, Your Honor, respectfully, you don't have the power to order my client to drug test this early in the case because you haven't officially taken jurisdiction over the case, so you can't make those orders. Now, in this particular case, I think the court and the other attorneys were surprised that I was making this argument, but in my opinion, that is the law in California. You don't have to drug test at the first hearing. I want to tell you, when social workers come out before the case even starts and they demand that you take a drug test, you do not have to take a drug test for a social worker. No social worker can make you drug test. And if they use that old argument, well, if you don't take the test and you miss the test, it's going to count as dirty. That's simply not true. That is not the law in California. Now, let me get something straight. If you do drug test in certain types of cases, it could help you. Now, you got to test clean, right? You can't test dirty. So before you agree or disagree to take a drug test, make sure you talk to your attorney or get some legal advice before you make a mistake. And by the way, drug tests are not 100% accurate. There is about a plus and minus 3 to 5% of inaccuracies in drug tests. So you could test positive by mistake, or you could test negative by mistake. So drug tests aren't infallible. They aren't the be-all, end-all. In a couple of counties in California, they actually use something called a patch drug test. And from my research, it is the most unreliable type of drug testing, but it's used in court in these two counties. I know Orange County, they use it frequently, but it's a very unreliable test. You and your attorney should review the federal policies and procedures and protocols for drug testing, because that is what controls whether the drug test is inadmissible or admissible in the court of law in the juvenile dependency case. Now, there's a whole series of things that you can go through to make sure that your drug testing is accurate, or as accurate as it can be. And this will be the subject of another video about how to defeat a drug test in juvenile dependency court. There are a lot of federal regulations the drug facility has to abide by before the social worker can use that drug test against you. And if you and your attorney don't object to it, well, you're probably going to lose. There is one other thing that I want to tell you in this video. You have the right to have a drug test retested. And I think in Los Angeles County, the facility is required, or most facilities are required, to keep the actual urine for approximately 1 year if you test positive. But you got to make your move and request a retest as soon as possible. In recap, drug testing is not permitted under California law at the first hearing or when you first meet the social worker. If you do want to drug test and you're absolutely sure you're going to come back clean, you might want to take the drug test. I always advise my clients not to take the drug test unless I'm sure that it's going to help us in the case. You know, I want to thank you for watching this video. My name is Vince Davis. If you want to give me a call and ask me questions about your drug testing case, give me a call at 888-888-6582. And if you have any comments or questions you want to ask or videos you want to see, comment below and I'll make a video on it. Also, please subscribe to my YouTube channel to make sure that you're notified when I put new videos out. And also like this video so that we can keep coming to you with these free informational videos that might be of assistance to you and or your attorney in your CPS case.